Hello, everyone. Am I audible?
Yes, Jess.
Okay. All right. Thank you. Violence against women must be addressed on multiple levels in multiple sectors of society simultaneously, taking direction from local people on how women's rights may be promoted in a given context. By working on the improvement of data and statistics on violence against women, adopting special legislation guarantees equal protection of the law and enforcement of its provisions. Governments can put in place the building blocks of a system that can respond more effectively to gender based violence. The allocation of resources, support to research, and documentation on causes and consequences of gender based violence, education, and prevention programs to support efforts to increase community responsibility, making information on women's rights readily available, and creating partnerships between governments and the NGOs are also necessary important steps. Good morning, everyone, honored guests, panelists, officials of LEB, PALS, staff, the PCLE Summit organizers, and to Dean Sherme Ovelos Dekang, my co author. My name is Jessica Moldes Wu, law student practitioner from Bukidnon State University, co-presenter for this research entitled First Responder and Interagency Collaboration Training in Handling VAUSI Cases. Next slide, please. Now, the local government unit plays a vital position in the prevention, protection, and addressing violence against women by directly cooperating with the people involved in cases of gender based violence. Moreover, Magna Carta of Women provides for the establishment of violence against women desk in every barangay. It is a barangay level facility that serves as a frontline service provider to victim survivors who experience physical, sexual, psychological, economic, and other forms of abuse. It is managed by a VAU desk officer designated by the Punong Barangay and is usually situated within the premises of the barangay hall. Procedures in addressing cases of violence against women and their children start in the barangay lupon and oftentimes with the assistance of the local law enforcement. The proposed training will help develop the knowledge and skills that are necessary to respond efficiently and appropriately, as well as escalation and de escalation in cases of violence against women and their children. This includes measures such as basic gender sensitivity training to properly respond to both parties in lupon hearings. It is important that the lupon and or law enforcement proactively advocate for the survivors' empowerment of their rights under the law. Part 1 of this proposal evaluates the lupon and the law enforcement's current knowledge in their procedural role and provides a critical view in involving them in the conversation of gender sensitivity, most especially that it involves violence against women and their children. Part two is approach through small and large group activities over a span of a number of days in cooperation with the local gender and development office, and more importantly, the local clinical legal education program of the municipality or the city. Through monitoring and evaluation, the local club can assess the knowledge and capacity of the lupon and the law enforcement in handling VAUSI cases efficiently. There are greater chances of prosecution of abusers, improved presentation of proof at trial, and the utilization of correct procedural measures to protect survivors and witnesses, in which the lupon and the law enforcement play a vital role in the empowerment of the survivors and the betterment of their lives. This interagency collaboration of the City Gender and Development Office, together with the Gender and Development Office of the university, ensures that the lupon and the law enforcement are drawing from the same training. Next slide, please. Now, for this paper, we aim to answer the question: what is the significance of CLEP interventions to VAUSI first responders case handling? Now, awareness and capacity sharing, capacity building within this community on violence against women has been growing due to national campaigns and government strict implementation on its agencies towards emphasizing the importance of decreasing the prevalence of violence against women. Although it requires acceptance and practice by all, especially in creating a sensitive approach, the constant reminder and articulation of the elimination of violence against women are needed. It is required, it is recognized under the international law that the state is responsible for acts of violence against women committed against them by private individuals if there is a failure in prevention, investigation of the acts of violence, punishment of the offender, and providing for the victims. Moreover, it is the state's responsibility to be due diligent in ensuring women's rights are implemented. It is enshrined in exercising respect, protection, and fulfillment to promote human rights. Due diligence includes the action of the state from the initiation of the complaint on a violence against women from the barangay level, with respect to the prevention, investigation of the violations of the perpetrator against the victims, and ultimately the recommendation of prosecution of the perpetrators through fair proceedings. In fact, in a study, clinics serving women subjected to abuse have the capacity to play a significant role in the further development of domestic violence law and policy in the United States. The formation of the clinic mirrored the grassroots effort of the battered women's movement. Early domestic violence advocacy focused on safety, shelter, criminal justice interventions, and coordinated community response (CCR), and aimed to transform public perception of domestic violence from a family matter to violent crimes worthy of effective legal and community response. The establishment of clinical legal education program in mainstreaming gender-based violence sensitivity training improves the utilization of gender neutral language rather, which reflects a greater understanding that patriarchy is at the cultural and historical roots of domestic violence. As a stakeholder, the local club aims to educate not just the students, which helps to integrate the teaching of practical skills and legal doctrine, elevating students' understanding of both, but the community while expanding and mainstreaming the community's response to domestic violence. Next slide, please. So what? Consequentially, this creates a relationship with the first responders, such as the barangay officials, appointed VAUSI barangay officer, and barangay health workers, community based organizations, Philippine Commission on Women, the first level courts, city social welfare development, city Philippine National Police officers, and more importantly, the Women's Desk Officer, and other agencies providing social services, including but not limited to shelters, rape crisis centers, local women's organizations, psychosocial services, recovery rehabilitation programs, livelihood assistance, counseling, and more. The establishment of the local club results in a more sustainable approach to local issues, which need a grassroots level of understanding. One innovative response to the shortage of advocacy services for victims involved with the justice system has been the establishment of law school-based domestic violence clinics in which law students volunteers are trained as part of a course or other forms of instruction to work as legal advocates for battered women. In addition, the community service develops and enhances the law school's constituency, which includes the bench, bar, and broader community. Necessary to the efficient implementation of RA 9262 is the first respondents' comprehension of the law to enable them to assist the survivor victims accordingly. The capacity building training includes, but is not limited to, participatory talks and interactive activities to raise the first responders' understanding of the law. The evaluation will specifically assess the barangay's programs, handling of violence against women and children cases, application for barangay protection orders, preparation for accepting or application for barangay protection order, services for or assistance to victim survivor, facilities and resources, personnel or VAUSI service provider, and referral of victim survivor or data to appropriate agencies. Next slide, please. The gaps and challenges for this proposal, since the local CLEP in Bukidnon in College of Law specifically, is on its first year. So we look into the following studies. According to the 2020 UNICEF report, there are referral guidelines for VAUSI survivors, but they have not been integrated, nor do they address intersectionality. So access to justice through VAU desk at the barangay, primarily through referral to the Women and Child Protection Desk at police stations. There are multiple barriers, include a large burden on victims to collect evidence from multiple resources, long and drawn out justice procedures, lack of sensitive or protective judicial processes, as well as economic and social stigma issues. The recommendation of the UNICEF report include intake forms and referral guidelines review to prompt integrative case management for VAU survivors. The staff at WCPDs and VAU desks would benefit from ongoing training and capacity building in VAUC issues, and the improvement in both national prevalence and administrative data collection and management, which high quality data could be used to inform ongoing policy, programming, and service work to comprehensively and effectively try VAUC cases in the Philippines. In assessment study conducted by Consigdano et al., it found not all VAU desks are in a separate room for intake interviews. Given the limited space of the barangay hall and the limited budget for the VAU desk office, as opposed to the DILG memorandum establishing the VAU desk to have a separate room from the intake interview. It also found that there are no policies indicating the distribution of the GAD fund for the operation of the VAU desk office. Moreover, the budget merely depends on the prioritization of the barangay, which is also based on the internal revenue allotment or the IRA and the income of the barangay. Whereas the DILG memorandum states that VAU desk shall have its budget for operation and services integrated into the approved barangay gender and development plan and budget, which shall be at least 5% of the budgetary allocation. The reporting of cases were also at 61.9% submission rate per month, in contrast to the DILG memorandum, which indicates that the barangay shall prepare and submit quarterly accomplishment reports to the city or municipal social welfare and development officer and the city municipal local government operations officer within 10 working days of the ensuing month. Another study conducted in the municipality of Bayambang concluded that most of the respondents are aware on the level of implementation of RA 9262 in the area of nature or character of the law. The findings also revealed that majority of respondents are aware on the filing process, penalties, and consequences. Therefore, the study recommended that the barangay officials must continue to acquire adequate trainings and seminars on how to deal with vow concerns, that they hold an annual seminar in regard to anti-vowsy law to teach women and children about their rights and protection, including dissemination and distribution of flyers or pamphlets containing the law to enable those who cannot attend the seminars to be also aware about the said law. Next slide, please. As such, the objective of this paper is the implementation of the action plans by the local club. Um, Enumerated, number one, training and capacity building, and conducted by one group of LSPs or the law student practitioners in the local club, will be focusing on training with the first responders. And the second action plan would be providing assistance to the victim survivors. Another group of LSPs will be paired with the victim survivor in pursuing their case. Next slide, please. Role of the local clinical legal education program for the first responders. Next slide. As reiterated, there is a need for constant training with barangay officials in handling VAUSI cases. The role of local CLEP in capacity building training for the first responders is to supplement the current government agency trainings on gender and development on handling VAUSI cases, and the following are the action plans for this research. Now, the first one, this framework is to provide comprehensive annual training of laws relating to VAUC to first responders, such as the barangay officials and the local law enforcement, as enumerated prior to this. Now, the key actors here would be the local CLEP that we will partner with the government interagency experts, NGOs, speakers from legal and the judicial profession. The desired output for this is for the local club to be introduced in the community as a law school based advocacy or educational campaigner on the RA 9262. And we hope to have an output that the participants will be able to know the applicable laws that could differentiate between a non-VAUSI complaint to a VAUSI complaint. And another output is that the participants will be more adept with the laws on gender-based violence and for them to create their own action plans on how to disseminate these laws to their constituents. Next slide, please. Now, we also would like to provide an annual gender sensitization training on administering VAUSI cases with the same key actors. And we hope to have an output that we will be doing this annually. Next slide, please. The third one is to streamline partnership between government agencies involving VAUSI proceedings, such as the local government unit, the local police, the social workers, and the community, with the same key actors. And we hope to provide an output of a map of procedures in administering VAUSI cases using the referral system guidelines, and of course, strengthening local hotline numbers per concerned agency for assistance of VAUSI victim survivors. Next slide, please. We hope to include the City Gender and Development Office and the Committee on Women under the City Council in the provision of budget, improvement of facilities, and awareness campaign with the same key actors. But more importantly, we will partner with the local government unit, Gender and Development Office, and the LGU Committee on Women. Um, we hope to have the proper utilization of local GAD budget for the improvement of the barangay facilities and anti-VAUSI campaigns during this action plan. And for the Committee on Women to provide for a higher budget for RA 9262 campaign implementation and to gather data on necessary facilities per barangay. Now, the capacity building training will be conducted by the local club every start of the academic year for enrollees of the clinical legal education program. The law student practitioners will be conducting the education training or seminar together with the invited interagency experts from Philippine Commission on Women, City or Municipal Social Welfare Development Office, local WCPD officer, non-government organizations, and speakers from the legal and judicial profession. Now, next slide, please. The second action plan is providing assistance with the victim survivors. Now, the role of the local clinical legal education program for the victim survivors is to emphasize in providing for support. And these are as follows. Next slide, please. To provide assistance from the initial visit to the barangay VAUSI desk to filing of protection orders applied by the victim survivors or up until the filing of complaints. Now, the barangay shall contact the local club when a VAUSI case has been initiated, and a group of two or more law student practitioners shall be paired with the victim survivor. And the local key actors would be the same. And then we hope to have a desired output after the first phase, and we would be gathering the data on the successes and challenges of the intervention by the local club. Next slide, please. To have a proper documentation and confidential logbooks for the proper reporting of the cases with the same key actors, and the gathering of the successes and challenges of the intervention by the local club for the assessment. And lastly, next slide, please. To have a sustained contact with the victim survivors to keep them engaged with the status of their cases. Because it was found in the study conducted by HADAP that one of the problems encountered by the barangay officials in implementing RA 9262 is the lack of cooperation or interest from the victims or relatives to pursue the case. In the law school-based advocacy study by Goodman, each victim, rather, in the experimental condition was paired with two, second or third year law students throughout the course of the semester. Students received frequent supervision from faculty attorneys and worked in pairs to see three clients, working with each from the start of her case to finish. In implementing the same to this research, the pairing of victim survivor will be with the law student practitioner under the local club. According to the Domestic Violence Evidence Project, women who worked with advocates experienced less violence over time, reported higher quality of life and social support, and had less difficulty obtaining community resources over time. Moreover, the experimental intervention involved the same level of advocacy for mothers, but also included a 10-week support and education group for children, which lasted 16 weeks rather than 10. Findings from this small study were modest but promising. Children in the experimental condition reported significantly higher self competence in several domains compared to children in the control group. The intervention also resulted in improvement in women's depression and self esteem over time. Furthermore, to close, an empowerment approach to domestic violence prevention should be observed because it is crucial not to replace one form of control with another by having advocates and others tell the battered woman that she should do and how she should do it. Thank you very much.
Thank you, Ms. Sandra Paredes, for the information. We will take note of that. From IRA to now national tax allotment, the proper term. Thank you. Thank you for the comment, Miss Bayona.
Hello, ma'am. Good
Hello po, yes.
morning. Oo. I'm a third year law student from the Arellano University School of Law.
Yes po.
Um, Kasi we have not yet experienced actual case handling for Club 1. I just want to know how does it feel to really be handling VAUSI cases? Is it allowed to be emotionally attached to the victim, or is that not allowed? Kasi in some cases, I I think that lawyers should not be emotionally involved. So how do you handle it?
Miss Jessica, can you share your experience?
Yes, po. Thank you, Miss Sandra, for the question. Um, I would also like to point out that before being a law student practitioner, I have always been an advocate for the victims of VAUSI in Dumaguete City and um, now here in Bukidnon. It's very hard at first. If your question is not to get emotionally attached to the victims, it is very hard to compartmentalize at first because as a person, as a human being, you empathize, and as a woman, you have you cannot stop from thinking that because there was a data that's one of three women in the Philippines are experiencing abuse. So you tend to think that in this group, one woman here has been abused already. And to answer that question, at first, you would still need to validate your feelings because it's important to acknowledge that it's very hard to process it first, because how can you process their problem if you yourself don't process what the information was given to you. So I do admit that at the very first, when hearing their cases. And recently, last Friday, we did a VAUSI legal, clinical legal education program here in the university. And I do admit that a lot of them moved me, even though I've been hearing some of the worst cases in the court and in the community, talking to victim survivors. So yes, I think it takes practice, especially you really want to fight for them. um and I think what you can do is uh to get better at what we do now and advocate, because the law is with us. So I hope I answered your question, Miss Sandra.
Yes, thank you. Because I'm a very emotional person as well. And it's hard to think, no, not to get emotionally involved. But, well, on the part of the NTA, I'm very well aware of that because I was formerly the director of the League of Governors. So I know the status of local government units with regard to their gender development. So I hope the LGUs will give more funding for this. Thank you.
Thank
Thank
you
you, Ma'am.
very much. In the Q&A, there was a question, were you able to get the number of IPs in Bukidnon? It refers to the previous presentation, no, that received legal aid services. My answer was that we are still collecting the data as we are in the process of needs assessment and consultation with the IP community. So we will update you on that. Thank you.
And I think there's another comment in the Q&A box. Thank you for this very interesting presentation. Thank you. Are there any plans to replicate this work with other legal clinics in the country? Yes, we hope that this will be replicated all over the country. This is our goal. Hopefully, we can finish the research soon. Thank you so much for the enthusiasm.
To add, the paper is designed to make a framework that can be replicated in other CLEP or other law schools. So that is the goal. Jess, can you read the next
Uh,
question?
yes po. From Abigail, thank you for your question. How do you balance not controlling the client with encouraging them to take action? Thank you so much. Um, yes, it's very hard because as an advocate, you already know where she should stand, but um we cannot control them, eh. It's their choice. What I learned in sessions, um that if you push them and they themselves are not ready, then it's going to be a waste of your time and your energy, and they themselves will not be empowered, and it would lose meaning. I hope I answered your question, Abigail. Dean, maybe you have something to add.
I agreed with Miss Wood, no? We cannot control the client, but we gave them options or we advised them on how to properly proceed with their case or what's the next move that they can do. Um, that's the role of the CLEP and the law students or the supervising lawyer to assist the clients or the victim survivors on their choices on what's the best option that they have and how they can avail of the options. So I think that is it.
Another question, Dean, from Ms. Apple Beneflora Lavares. What are your recommendations on how to get the victims to talk when you need to get further information? Fear and self-blame are the most common challenges that causes these women to clam up. I do agree. Um, I'll just share our experience. No, last Friday, there was a student who shared about her experience, and she, along our conversation, she opened up. At first, she cried. Actually, she cried at the inception of our legal advice. She was crying in front of me, and I was shocked because we were just, you know, talking to other to previous students who wanted advice, but this girl, she came up to us, and I realized that her mannerism, because you have to look at their mannerism first, because she was very shy. So I, instead of her being in front of me, I called her to sit beside me, and it we have to be careful, um, because when we tend to talk to the victim survivor, there are a lot of non verbal cues that you have to look at before you tell them. You have to let them open up first. No, you just listen. uh I think the reason why she opened up is because, um I think I just asked her what what she needed help with, how could we help her. And along the way, she first cried, and then I allowed her to cry. And when she said that she does not like the presence of men, so I asked the LSPs who were there, who are men, to at least go farther, no, because it will affect her emotion and as well as her sharing. So it will not be as effective as we want to. So it was just me and another LSP and the girl. So she opened up with her experience, and I just listened without interrupting her. So I think it's important that we just let them talk, listen, and ask the questions without giving them a lot of information yet, because they might give you an information that is not applicable or that is not appropriate to what you're gonna see. So we have to wait for them to open up. And eventually, she opened up, and um, we finally ended the conversation. But she did not want to pursue the case because what she was having trouble with is going forward, to authorities, to guidance counselors, to assess her psychosocial. She does not want to talk to men, the police officers. So it was a very sensitive, it was a very sensitive case for her. So I did not push that, hey, I know what this needs. I know what you need to do next, so you should go here. No, I did not do that. But I rather told her that when you're ready, we'll still be here. When you're ready, the law is still with you. And then she appreciated that. So I think it helped her gain confidence, and I thanked her for being courageous enough to come up to us and tell her story. So I hope I answered your question, Apple.
So just to add, last Friday we had our legal aid consultation in celebration of the 18-day campaign against VOW. So we brought the law students, the LSPs there in the university for the legal aid consultation with the personnel and the students of the university. And the experience of Miss Wu that she shared was very significant in the LSP's realization on what she can do or the other LSPs in the future. And also, as a background, we have orientation for the LSPs with our supervising lawyer. Good thing that our supervising lawyer is a psychology graduate. And we have guidance from the guidance counselors. They gave us orientation on how to handle these victim survivors, and also uh, how to react, how to behave when we interview our clients in the future. So that is one best practice that we can have in our CLEP. So the next question is: have you encountered mixed parentage child demanding for support from his or her foreign parent? For me, in practice, yes, I have encountered two cases, in fact, and but how is it significant in our? Do you mean that they are the victims of VAUSI or financial abuse? Is that the direction of the question? For financial abuse, or for parents, or for the women or the mother and child asking for financial support, we also advise them on the procedure, on the manner that we can proceed with the case. And then one was settled. They have it was successful. The parent was able to provide support for the child, although his parent is in another country. So that's one update on that case. The other case was referred to uh, the DSWD because the mother does not want to ask for support, but the child requests for the support because she will be in college. So I think that is one area where there is a gap when the child asks for the support, but the mother does not want to pursue the case for parental support. In your VAUSI CLEP program, do you consider special initiatives on men's education on this matter? Others considered some men's ignorance or sense of impunity as a factor in the rise of VAUSI cases. They are similarly key stakeholder in between. Yes, Mr. Baisal. We have in one gender and development training, the men has a role in this campaign against VOW, and they have to be oriented. They have to be trained on also on how to handle these kind of cases. We have personnel in the university that also have the same concern on the education of men on VAUSI. And they, in fact, are asking if they also have rights against abusive wives or partners. So we said that the PCW advised them that they have to report the cases if they have encountered victims who are in those abusive kind of relationships, so that they also be given um, uh, their needs will also be responded. For the VAUSI, it came about from a research that majority or 90% of the cases on abuses or physical injury are from women who are abused by their husbands or partners. That's why VAUSI was being implemented in as a law now.
May I add, Dean?
Yes, yes.
Thank you, Attorney Paisal. Um, this question actually, this was my policy paper in Gender and Development, Dean, if I remember it correctly. It was, it studied the role of men in building or creation of violence-free communities through training the men in these communities. Actually, my model organization comes from Negros Oriental, specifically Dumaguete. They are under the gender, the G Wave. I forgot the complete name, but they are under G Wave, and these are actually men from different municipalities, and they've had their trainings, and they are actually growing. And because of this, a lot of campaign that are spearheaded by men in the communities are gaining ground, and thus it is creating a safer, a more safe place for the women in Negros Oriental. So I do hope I can look for that paper, but it is actually it has already been done. That yes, men play a vital role in creating a violence-free community.
Yes, we will share a copy of the paper, Attorney Faisal. So, the next question: how do you handle those cases of the victim survivors who suddenly decided to back out due to reasons like for the sake of the children or out of their love for their abusive partner, perhaps? What do you think, Jess? We have an experience that a client backed out from the case. The barangay advised them to have a counseling, marriage counseling. And then if there is a chance that the wife comes back to the barangay and files another complaint, they will advise them that this is the last chance that you will be able to file a complaint. And if you will not pursue it again, then we will not be able to entertain you. So there is a reorientation, a briefing of what will happen if the case will not be pushed through, or if there is a chance that they will go back as a couple, as a family, then they need to do everything they can to make the relationship work. So that also, if there is a need, if there is really a need for them to have therapy or counseling, the barangay will be able to give them or refer them to a counselor. So that's one initiative of the barangay that we have encountered. What agency do you recommend for victims of domestic violence who needs housing assistance, legal help, and counseling? Jess?
What I read from the research papers for related literature, that ideally they go to rape crisis centers or housing that are specifically by NGOs. Um, Sadly, it's not everywhere. It's not practiced everywhere. Needs funding, but this is actually what we aim on, to have in a community, to have a safe space for victim survivors. Hopefully, with higher provisions for RA 9262, we would have that in cooperation and partnership with the local government unit.
Our city DSWD office has provided the building for the victims of vows. So I think that is one project of the DSWD to provide housing and counseling and other assistance that they need they can provide for the victim or the survivors of vow. Thank you, thank you. Yes, we will provide Miss Maria Luisa Reves. So I think that is it. We are done. Thank you, everyone. Thank you for your interest, and we love
Thank
your
you.
comments. If you need our copy of our paper, we will provide them with a lab, and we will email them to you as soon as we can. Thank you, everyone, and
Thank
um,
you.
have a happy weekend. Enjoy your weekend.
I think with the revised rule, one of the things that it did was that it institutionalized um, the reality that there is so much inequality. There are marginalized and vulnerable sectors, and we have to do something about it. Before, we only hear about it. Some are more aware than others. But since now we have the revised rule, and in the revised rule, again, there's that preferential treatment for the marginalized and vulnerable sectors, then it becomes a mandate.
We should consider CLEP as a way of getting students to be practice ready. This means they are exposed to the handling of actual cases and matters, dealing not only with clients but also with the courts, administrative agencies, institutions. CLEP teaches our law students what it means to be a lawyer in the real world, rather than being limited to cold and clammy books and cases, and then they get surprised when they actually interact with the people when they are already in the law office.
Your law school clinic administrators and supervising lawyers are asked to reflect also on what they have been doing already in terms of the exercise of their profession. Like, have they been doing what we were really asked to do in the first place? That is really public service. Law, really, the legal profession is public service. But sometimes, or maybe all of the time, when we go into practice already, we forget about that. Our lives are already occupied by more of the interest of our clients and the interest of your interest as a lawyer. You forgot that first and foremost, the legal profession is for public service. We are public servants.
I think the revised rule will help develop lawyers who have heart for those who are in need. We also help an elderly woman who would have been deprived of her property if not for the support of ILAW and the student volunteers. So the importance, I think, is because we immerse ourselves with the legal issues, work with the marginalized and those who need legal assistance. Through the rule, we will be able to form lawyers who will have an understanding not only of the law as it is written, but how it impacts the lives, how the law impacts the lives of the people that we will serve in the future. So I think working under the rule as students, we are able to understand not only the legal problems, but also some of the structures of injustice that are facing our country.
With CLEP, the law students are given the opportunity, because they're out in the field, to really rethink, what do I want to be when I become a lawyer? What kind of service do I want to? Do I want to go to litigation? Do I want to go to policy making? You know, in the past, before clinical legal education was really introduced through Rule 1388, law clinics were really mostly litigation clinics. We forgot that lawyers are not just litigators. Lawyers are engineers. They build institutions. Lawyers are policymakers. And this one CLEP is bringing to the table. Telling the student, what do you want to be? Do you want to go into litigation, policy making, or do you want to go into building institutions?
The first is always a preferential treatment for the poor. We have to realize that we live in a world that there is so much inequality. When we see that people are equal, the reality is in law and in essence, we want that kind of equality. But factually, there's so much inequality. And access to justice, for example, might sound very good, very well. Everyone can access justice. But because of inequality, it is not true for many people to attain justice. So having that frame of mind of preferential treatment for the poor gives that insight that we must do something to give them, to allow them to attain the equality in law that we want.
Empathy. You must have that in order for you to serve well. Even if in whatever profession you need empathy. Service only comes, you only deliver excellent service if you are able to experience what your clients are experiencing, and you are able to give the appropriate service if you have that empathy. The clinical legal education program is the one that provides the opportunity for one to be empathetic, to really care. Empathy is really care, to really care for your client.
You have to keep your integrity intact because you may not win initially, but it's a process. It's a process of change. Sooner or later, you will succeed. But what is the worth of that success if you give up your integrity?
One must be ethical, or else the services that you give might be, of course, for the client the best, but if it is not ethical, it wouldn't really serve the public, and that would only be for a short run. If your service is just to help your client without looking at the repercussions of that help to the community.
You have to be an advocate of your case. The law is the basis, but you also have the factual circumstances. But these are tools. So if you are an advocate, you have to be creative. You have to stand by and stand for your clients. No, you can't just tell them, talo na tayo. You have to fight for them. You have to believe in that case. And that's what being an advocate is. No, you don't just give up. You really fight for them, and you give it all.
A law student practitioner has to have that attention to detail because we have to deal with the nitty-gritty of the law, and how do we use that nitty-gritty of the law to protect the rights of our clients.
Of course, professionalism. Yeah. We just don't have to have the empathy or be ethical. We must know our work well. We must be excellent in what we do. We must be on time. We study. We know to research, and that's professionalism.
With CLEP, we are training our law student practitioners to be practice ready so as them not to be shocked when it comes to actually filing pleadings or actually filing cases in court. They won't be shocked anymore when it comes to really dealing with anything that is connected to the legal profession.
And I'm looking forward for a day to learn how to work with, argue with, and be with our lawyer friends in the courtroom and pursue, because I think it's important. It's not only that because you'll experience it as you will do it later when you become a lawyer, but more importantly is you can journey more with the clients that we serve. Not only in the interviews and writing the affidavits, but also really championing their cause in a way. So I think it's exciting, and also hopefully if there are more and more student practitioners who are doing it for the clients, then we will bring access to more of the Filipinos in need of support of legal aid in a way.
With me having 5 months of being a law student practitioner, it taught me to be more service-oriented. It taught me how to go beyond what is written in the law. I was taught, and maybe my other co-law student practitioners, where we were taught to be more service-oriented. We have to be compassionate with every client that we encounter, and we are to make sure that with our legal knowledge, we are able to help those who have less in life.
Rule 138A is really allowing the law schools to walk the talk. All law schools, I think, in the country would say that they want to offer transformative and relevant legal education. But what is really a transformative and what is really responsive legal education? Look at your law students, and they are really adult learners. And as adult learners, they will be asking for relevant pedagogy. They want to know the relevance of what they are learning. They want to see the real application of what they are learning. They want to see the meaning of what they are learning in the law schools. So CLEP allows us to do that. Experiential learning is really the way to go. And so it is allowing us to be responsive, be transformative, as we have declared ourselves to have and to offer.
CLEP brought home the need to enhance the way we teach, because we have been really teaching it like we use Socratic most of the time, lecture method. We forgot how important experiential learning is, and that was what CLEP contributed to the pedagogy in law school, to remind all of us that experiential learning has a very, very important place in teaching the law. And it reminded us also that our students can serve while learning. They don't have to wait to graduate from law school. That while they're studying their lesson, they can serve. And when they serve, their learnings, their knowledge are deepened. In fact, uh, that's the point of experiential learning, no? You deepen your knowledge of a subject matter by really actually applying the principles you've learned, implementing the policies that were shared to you in the classroom.
I'm hoping that with the new rules on externship as well as clinical education, that the pedagogy will really be transformed by veering away from a very purely doctrinal approach to a more experiential approach. And the two of them don't need to be inconsistent. They don't need to be antagonistic to each other because they can complement each other. Doctrinal professors can actually take on a clinical approach in teaching. And the best example I can give to that is procedure subjects. Many students fear or dread procedure subjects because they're boring. You memorize rules, you do checklists, but you don't see how they're applied. But if a doctrinal professor in civil procedure, for example, allows students to observe clinically and even experience clinically what it means to draft a motion to dismiss, what it means to go to court, what it means to observe a cross-examination or a direct examination, or to come up with a judicial affidavit while taking up civil procedure, then I think it guarantees that the learning will not only be significant, but the learning would be permanent, I think. The student would learn not just the theory, but the student would also learn the application.
This is a big contribution to their legal studies. CLEP helps integrate the various laws and concepts that they learn throughout law school. It helps them understand how law actually works. And, according to this theory of learning, the best way to learn is by doing. And so the law student practitioner experiences how the law works. Hindi lang niya binabasa, he just doesn't read about it, but he experiences it. And they will remember it better.
I think the first thing that a CLEP administrator or clinic administrator should realize is that clinical education is very different from the traditional form of education that we're used to in law school, which some people would call the pedagogical or the doctrinal approach, wherein you teach students what case law is, what the statutes are, because clinical education is experiential education. It is learning by doing, it is learning by observing, it is learning by witnessing. And so a clinical administrator is someone who is able to explain in practical terms, by words, by actions, is someone who is also a mentor, is someone who is a companion, is someone who can break down complex theories and show them to a group of interns. It is also someone who will allow himself or herself to stand aside and let interns experience how it is to handle a case, draft a substantive position paper, come up with substantive research, and so those are not things that we are used to in law school, in traditional legal education. So a clinic administrator, I think, must consider all of those.
I acknowledge that putting in CLEP into our law schools with varying resources can really be very challenging at times. We would find ourselves needing, for instance, a lot of supervising lawyers, find ourselves needing a lot of resources. But in the midst of these challenges, if we only will keep in mind the reason why we need to do CLEP, which is that learning the law while serving the community, we will not lose our way. So that is what I want us to keep in mind always.
They are there to guide their students, become the lawyers that their student, become the lawyer that their student would want to be. Meaning they should take away already being the expert, that I'm the expert so you follow me, but they are there to guide, to bring out the best in the law student. I've been interviewing students for admission to the law school, and although some would enter law school because, of course, for professional advancement, but even then, even if that was their primary reason, they will always say that they want to serve. So in all those students who go to law school, there is that spirit of service. They want to make the community better. And so the role of the law clinic administrator or supervising lawyer is to really nurture that desire, that love, that passion to serve. And you cannot do that by being the sage on the stage, because you might just be teaching your own way of doing things, and it wouldn't really help. In the words of Dame Joanne, let's allow 1,000 flowers to bloom. And for 1,000 multicolored flowers to bloom, we allow the uniqueness of our law students to come out, that unique service that they can give to the community. And that can only be done if you are a guide on the side.